supervision really are.
Well, I don't know that we have the time to dive into all the issues that are raised by that. One of them is, do we need more parole officers? If they have that many individuals on their caseload, maybe we need more parole officers. It may reflect that people aren't being adequately monitored on MSR. We have issues with recidivism rates in our state that there's even a need for more data around those recidivism rates. So that can be reflected in a lack of supervision on MSR. We see anecdotal evidence from time to time where an individual has been arrested a very, very large number of times and then is committing heinous offenses. And the question is, were they on supervised release, or should they have been under prior laws under supervised release? So I think just because you have a group of people that say, well, we don't see the need for it, it may be that there should be more resources given to parole officers. So I think, as I pretty well clearly outlined, I'm going to have to be a no on this, but I do thank you for your presentation.
Are there other questions? Seeing none, clerk, please continue the roll.
Slaughter,
Yes.
Cassidy,
Yes.
Windhorst,
No.
Cabello, Davis,
Yes.
Freeze, Gonzalez, Guerrero Cuellar,
No.
Gazzardi,
Yes.
Olico,
Yes.
Sheehan, Tipsword. Oh, yes, she is. Jimenez.
With 8 votes in favor and 5 votes opposed, House Bill 5256 is declared passed and will be favorably reported to the House floor. Continuing on the order of Slaughter, what's your pleasure? Let's go with House Bill 5270. Let me get some witness slips up. We have 85 proponents, including Illinois Collaboration on Youth, Thresholds, Illinois Alliance for Reentry and Justice, permission to waive the remaining. 1 opponent, Mike Zaleski from the Illinois State's Attorneys Association. Chair Slaughter, go ahead.
All right. Thank you, Madam Chair. Thank you for your patience. Very interesting bill coming up here. I am committed to holding on second to continue to work with stakeholders, address concerns primarily from the State's Attorneys Association and also the Department of Human Services. But House Bill 5270 amends the Juvenile Court Act of 1987 and creates an appropriate fitness standard for assessing young people in court delinquency proceedings. Really what we're trying to do here is address the urgent need for a more developmentally appropriate and trauma-informed juvenile fitness standard. Under current law, the standard uses to assess whether a young person is mentally fit to participate in their defense is identical to the standards used for adults. This one-size-fits-all approach fails to recognize the natural limitations in function, social, adaptive, and intellectual abilities that are inherent to our youth. Implementing a trauma-informed and developmentally appropriate fitness standard will protect young people's right to a fair trial, promote rehabilitation, and reduce the risk of harmful long-term outcomes. Recent federal actions, such as the current administration's calling for children as young as 14 to be tried as adults, signals a troubling shift in the juvenile justice system away from a lens of rehabilitation and into more of a punitive realm of adult court. Now more than ever, Illinois must take decisive action to protect young people by solidifying safeguards and ensuring developmentally appropriate services. By adopting these standards, Illinois would join 32 other states that have implemented juvenile fitness statutes, bringing the state in alignment with best practice. Really, what this does is look at three main areas. In regards to the diagnosis, it expands the determination of unfitness, where it would no longer require mental illness diagnosis, and recognizes a broader range of factors for unfitness. But when you think about evaluation, what we're doing here is updating the criteria for evaluation, which would include traumatic stress, substance abuse disorder, and considerations of chronological, developmental, and relative immaturity. Lastly, what it does is broadens treatment services. And so now we want to enable evaluators to recommend services to address conditions contributing to the unfitness. With that, Madam Chair, I do have Dr. Jennifer Rowland here to provide testimony from ICOI, as well as Allison Richards, who's been working on the bill as a lobbyist. Thank you so very much.
Great. And to reiterate, you are holding on second and coming back?
Yes, holding on second to come back to address concerns, mainly with DHS and also the States Attorneys Association.
All right. With that, if y'all want to proceed with very brief testimony, since we're going to be hearing from you again.
Yes. I don't want to.
Turn your mic on.
I think it is on. I just kind of talk low, so I apologize.
You got to get right up on it.
Okay. I don't want to double back on what he said, so I want to thank you all for having me here today. And I just want to point out that, and I am Dr. Jennifer Rowland, as he said, from ICOI, the Illinois Collaboration on Youth. And I just want to point out that this legislation has been developed over the past 6 years, and it has been in coalition with several justice and youth advocacy organizations, spurred by a strong belief that youth are substantially different from adults and need a process that recognizes their unique needs and builds in specialized protections for them. I also want to underscore that in the current time, we are very concerned by signals we are seeing from the federal level. The current administration has called for children as young as 14 to be tried as adults. And this is a concerning shift away from the rehabilitation-centered approach of the juvenile legal system, and it's towards a more punitive adult system. And it is imperative that we take a swift action to enshrine protections to ensure our youth are treated justly. As I want to remind you all that young people are not miniature adults, so we shouldn't treat them as such. And I do want to say that this bill is grounded in brain science, and it is trauma-informed.
Thank you. Did you want to add anything?
No, thank you, Chair. Only here for questions.
Great. Questions from members? I think we're going to hold questions until we see you back here. All right. Seeing no further debate, Representative Gonzalez moves that House Bill 5270 do pass. Do we have leave? With partisan leave being granted, we have a vote of 10 in favor and 5 opposed, and House Bill 5270 is declared passed and will be favorably reported to the House floor, and we look forward to seeing you back.
Thank you, committee.
And then we've got Chair Slaughter on House Bill 4367. I'm going to pull up those. There are 378 proponents, so just a little flavor: Women's Justice Institute, Muslim Civic Coalition, Mano a Mano Family Resource Center, Illinois Alliance for Reentry and Justice, permission to waive the reading of the remaining 300. Spokes, can I get permission to waive the reading of the 378? Thank you so much. And in opposition, we have one from Mike Zaleski from the Illinois States Attorneys Association. With that, take it away, Chair Slaughter.
Thank you, Madam Chair, members of the committee. Here before you on House Bill 4367. This bill allows people who have already served their sentences and are no longer in custody to access post-conviction review under Illinois law. Illinois is one of only 5 states that doesn't give non-incarcerated individuals a pathway to challenge the legal validity of old convictions. The federal system and 45 other states all allow people who are out of custody to seek post-conviction relief. Really, with this bill, we're trying to help and assist and support communities of color, specifically black and brown communities. We know the disproportionate impact that the black community has had in regards to the system. But we also want to address, and this bill has implications on the immigrant population. Without the challenges in this bill, people with low-level cases or very old cases can be deported or subject to lifelong denial of lawful immigration status. I do want to also say that the bill will not automatically erase anyone's conviction. It doesn't prevent someone from being convicted and sentenced again in their reopened case if relief is granted. In regards to implications on the immigrant population, this doesn't grant anyone a special immigration status. With that, I do have with me Dave Fierity from the National Immigrant Justice Center, and also Greg Chambers from the Illinois Coalition to End Permanent Punishments for testimony.
I'm going to try to be brief here. For decades, I've advocated on behalf of people fighting for their lives for second chances. I've watched the frustration.
Mr. Chambers, can you state
Can you
your
please
name?
state your name for
I'm
the?
so sorry about that. My name is Gregory Chambers. I am the Director of Policy for the Illinois Coalition to End Permanent Punishments. And that last name is Chambers. Okay, for decades, I have advocated on behalf of people fighting for their lives, for second chances. I've watched the frustration of those navigating the most unforgiving area of our justice system, filing successive post-convictions. The stakes of this work is unimaginably high, as 538 people in our state have been in prison for crimes they did not commit since 1989, losing an average of 8 years of their lives. Murder accounts for a staggering 43% of these Illinois exonerations. Yet, as anyone familiar with this plight knows, constitutional and statutory rights and privileges to challenge convictions are completely useless if the procedural bars are so impossibly high that a person cannot navigate them. Under the current law, the Illinois Post-Conviction Hearing Act strictly contemplates the filing of only one petition. To even get a second petition heard, an inmate must pass a rigid cause and prejudice test to prove their initial proceedings were deficient in some fundamental way. In practice, this creates an unrelenting procedural nightmare. I have seen heartbreaking cases where inmates were trapped in severe prison lockdowns and denied access to the law library, yet courts still deemed their petition untimely and threw out their claims without ever looking at the merits. This is why I strongly urge support for the proposed legislation in House Bill 4367, which will finally provide equal access to post-conviction relief. This legislation will fundamentally ease the burden associated with successive petitions by tearing down insurmountable procedural walls that keep the innocent behind bars. Under HB 4367, any petition asserting that newly discovered evidence of actual innocence requires vacating a conviction will be deemed timely filed at any time. It explicitly removes the strict time limitations that have historically silenced wrongfully convicted individuals. Furthermore, this legislation guarantees a fair opportunity for relief by acknowledging the complex realities of our most vulnerable defendants. It creates specific pathways to present meritorious claims to modify a sentence if a person's participation in a forcible felony was the direct result of suffering from postpartum depression or psychosis, or if they were the victim of domestic or gender-based violence. It also ensures that individuals whose convictions are legally invalid because they were not made aware of severe immigration consequences can petition the court regardless of their citizenship or criminal custody status. Proving a wrongful conviction through witness recantations, withheld evidence, or faulty forensics is already a monumental task. We cannot continue to let rigid procedural technicalities compound the tragedy by denying innocent people their day in court. By passing this bill, we ensure that the pursuit of truth is not blocked by arbitrary deadlines, thereby transforming our system from an impersonation of justice into one that provides a genuine, accessible path to freedom. Now, in closing, as you consider whether or not to support this measure, just remember that Illinois is one of only 5 states that doesn't allow formerly incarcerated individuals to challenge the validity of an old conviction. It is too late to take the lead here, but it's not too late to do the right thing. Thank you, Mr. Chairperson. Thank you, Vice Chair. And thank you to the committee for allowing me to speak here. I appreciate you.
Do you also wish to provide testimony or just answer questions?
I can answer questions just very briefly. I'm Dave Faraday. I'm from the National Immigrant Justice Center, just on the immigrant side here. As Chair Slaughter mentioned, this bill is addressing the problem of non-citizens who entered guilty pleas and did not have the benefit of any advice as to the immigration consequences of entering that plea. And then years later, when they actually suffer those immigration consequences, there's nothing for them to do to go back and try to fix that. Because on under the Post-Conviction Relief Act in Illinois, it's bound by this in-custody status, that only people who are in custody can actually pursue that relief. So this addresses that. I'll just mention there was the opposition slip from the State's Attorneys Association. We read that. It was just filed today. We're happy to work with them to see if we can have a meeting of the minds. But otherwise, I'm happy to answer any questions. Thank you.
Thank you. And just for some context for folks, I think that we passed the admonishment law maybe less than 10 years ago. So prior to the passage of that bill, where people entering into plea agreements were admonished as to the potential for immigration consequences, you're correct. There was nobody getting that advice, and now you're getting maybe one line, but it's more than we used to do, and it has been fewer than 10 years. I can't remember when I passed it, but it's back there somewhere. Are there any questions from members? And go ahead. And you are coming back with an amendment, or you may come back with an amendment?
We're committed to hold this on second to
Okay.
address
Thank you.
concerns.
All right. Minority Spokesman Windhorst.
Thank you, Madam Chair, and we'll wait to ask to hear from the state's attorneys until after we see the amendment. I would like to point out something that, as you consider changes, that I think is going to be a problem with this going forward. It's record retention from local law enforcement and prosecutors' offices. So a case is resolved, let's say a misdemeanor theft, which could affect someone's immigration status. Most law enforcement agencies and state's attorneys' offices are retaining those records for only 7 years after the case is resolved. So that means if an individual comes in and says, well, I'm actually innocent, there would be no records for the prosecutor or the law enforcement to have to contradict that information. The other thing is, my understanding is it applies also to court supervision cases, meaning pleas of guilty without a finding of guilty. Those are eligible for expungement. So it's possible that you have a case that's actually expunged. There's going to be no evidence of it anywhere. They're not in the court system, not at the prosecutor's office, not in the law enforcement officer's department. So I think that's going to present a real problem for older misdemeanor cases and for there to be an actual hearing that gets to the truth of the matter, not just allegations that are made. So I don't know how we address that other than rewriting our records retention policy, but that will only be effective going forward, not for anything in the past. Thank you.
Do you have a response to that?
Yeah, I mean, if I may, I mean, to the expungement part, I mean, part of this is expungements have no effect for immigration purposes. So I think that's why the scope of this is that broad, because really immigrants, the only way that they can get a conviction to not count for immigration purposes is to vacate it. And I guess, like, just broadly speaking, I mean, I'm not a prosecutor. I've never worked in a prosecutor's office, state's attorney's office. I will say, though, Illinois is the, a minority of states that doesn't have a much more expansive post-conviction relief vehicle. Indiana has absolutely no statute of limitations. Doesn't seem to be a problem. I mean, I'm sure, we'll let them, obviously talk to that, but it seems like it's only a problem or potentially a problem in Illinois. So I'm not sure, if it actually is as much of a problem.
I can't speak to any other state's laws. I can only speak to the fact that it's very foreseeable that if you have an issue 10 years ago that's now brought up in court and an individual saying, I'm actually innocent, and there are no records to call witnesses, to provide any documentation to contradict it, I don't know how a prosecutor's office or a police department is going to be able to defend that conviction through no fault of their own. They were complying with the law all the way up to this point, and now they have a new law that comes into effect that is retroactive in scope that was never foreseen when the records retention policies were adopted, provided in law. I just foresee a huge gap that maybe other states had already foreseen when they introduced their law. Maybe their laws weren't retroactive when they introduced them, and they changed their records retention going forward, which would be a discussion we could have. But when you have a retroactive scope, it's going to be a problem.
Chair Slaughter?
Yeah, and I would just say, Spokesman Windhurst, a very, very important, valuable question that you're raising. One that we are certainly working to get a good answer to. And I would also say, just along the lines of what Mr. Faraday was saying, 45 other states do it. I think it's an important opportunity to look at some of the best practices as it relates to records retention and management and how this has an effect on this bill.
Great. Are there any other questions? Seeing none, Rep. Gonzalez moves that House Bill 4367 do pass. Do we have leave? With partisan leave being granted, we have 10 votes in favor, 5 votes opposed. House Bill 4367 is declared passed and will be favorably reported to the House floor. Slaughter back in the chair.
Thank you, Vice Chair Cassidy. Okay, members, the last two bills here. Representative Oloko, going to take us home here. The chair recognizes Representative Oloko. Which bill would you like to do first? I'm sorry.
5310.
Okay. Chair recognizes Representative Oloko to present House Bill 5310. The floor is yours, Representative.
Thank you, Chairman Slaughter, Spokesperson Windhorst, members of the committee. I'm here to present House Bill.
Can barely hear you.
I'm here to present
There you go.
House Bill 5310, an initiative of the Office of the Cook County Public Guardian. This bill ensures consistency among the articles of the Juvenile Court Act for the transfer of cases between counties by adding specific timeframes and guidelines regarding jurisdiction when a court orders a transfer. Each article of the Juvenile Court Act has a section that addresses venue and allows a court to enter an order to transfer cases between counties. In 2021, the legislature amended Article 2 of the Juvenile Court Act to provide for specific timeframes and guidelines for jurisdictions regarding the transfer of cases. The legislation passed unanimously. Articles 3, 4, and 5 contain the original language for venue and are not consistent with Article 2. HB 5310 simply amends Article 3, 4, and 5 to include the specific timeframes and guidelines set forth in Article 2. The Sheriff's Association was initially opposed, but has withdrawn their opposition and has taken a no position. Again, this is initiative of the Law Office of the Cook County, Law Office of the Cook County Public Defender and the ACLU are in support of the bill. I have Elise Melrose here from the Office of the Cook County Public Guardian to offer to answer any questions.
All right, thank you, Representative Oloko. Just going to pause for witness slips. You've got 6 proponents: Cook County Public Guardian, of course, ACLU of Illinois, Illinois State Bar Association, and the Cook County Public Defender's Office. No one slipping in opposition. You do have on a no position the Illinois Sheriff's Association and Illinois State's Attorneys Association. With that, any questions, members, on House Bill 5310? And I'm sorry, are you here to provide testimony, answer questions? Okay. Members, any questions on House Bill 5310? Seeing none. Representative Davis moves that House Bill 5310 do pass. Leave been granted, and there being 15 votes in favor, 0 votes opposed, 0 voting present. House Bill 5310 is declared passed and will be favorably reported to the House floor. Thank you, Representative Oloko. For our last bill of the evening, Representative Oloko, we recognize you on House Bill 4303.
Thank you. House Bill 4303. This is the Parole Fairness Modernization Act, an initiative of Project Soundoff. Prior to 1978, Illinois operated under an indeterminate sentencing system. Individuals sentenced under that system remain subject to parole supervision for the duration of their maximum sentence. After 1978, Illinois transitioned to a determinate sentencing system with clearly defined mandatory supervised release caps of 1 to 3 years. House Bill 4303 eliminates this disparity by aligning supervision terms for pre-1978 sentences with the same MSR caps that apply to everyone else in Illinois. The legislation does not release anyone from prison, reduce underlying sentences, or compromise public safety. It simply modernizes supervision policy for a small remaining group of subject to the outdated statutory language, which would impact approximately 34 individuals currently on parole supervision. These individuals are in their 70s and 80s. House Bill 4303 tries to correct a longstanding disparity in the Illinois supervision law. Individuals sentenced prior to 1978 remain on parole for the duration of their maximum sentence, while all modern sentences are capped at 1 to 3 years. I am coming back to this committee like with an amendment. We learned that there may be some other efforts that may make this duplicative, and had some concerns have been raised that we're going to continue to have some conversations, but happy to answer any questions.
Thank you, Representative Oloko. Just pausing for witness slips. You do have 53 proponents. Leave, Mr. Spokesman, and not read all of those. I believe it's granted. You have one. Well, let me just see who. You have one opponent, the Illinois Sheriff, and then I believe it's the Illinois State's Attorneys Association that slipped on a no position. Can you go back to the proponents? Some of your proponents: FAM, Illinois Alliance for Reentry and Justice, Institute to End Mass Incarceration, Project Soundoff, of course. With that, any questions on House Bill 4303? Spokesman Windhurst, does she have?
Thank you, Mr. Chairman. I'll be brief, being as we'll, I guess, be seeing this again. You said there were 34 individuals in the state this would apply to. Is that correct?
Yes.
Are they all convicted of murder, or are there other offenses? Are you aware?
I don't know if they're all murder, but some of them are.
Yeah, I would say probably just based on all the
Based-
times involved, I would say probably almost all of them, if not every one of them. And so they would go from the parole system that we had previously to mandatory supervised release, which would be 3 years. They'd be
Yes.
placed on 3 years. And of course, we just had other legislation that may make that day for day eligible if that were to pass. But I know that's not your bill,
Yeah.
so I'm not going to hold you to that. All right, thank you.
Representative Grail Crayar.
That was great pronunciation. I'm gonna need you to. We're gonna do this every committee, so you can just practice. Representative, can you tell me what's the nature of the amendment?
So part of the reason we're holding, Chairman Slaughter is working on some sentencing legislation that this may become duplicative. DOC hasn't taken a position, but I've committed to talking to them if there is a specific issue that comes up. And there was a question about a petition, possibly petitioning, so I'm opening to hear some more feedback. I know the sheriffs had expressed opposition, but we have not had a chance to communicate there, so.
Okay, thank you. That's all, Chair.
All right, thank you. Any more questions? Seeing none. Representative Davis moves that House Bill 4303 do pass. Partial leave being granted, there being 10 votes in favor, 5 votes opposed, 0 voting present. House Bill 4303 is declared passed. It will be favorably reported to the House floor.
Thank you.
Thank you, Representative Ola. And with that, there being no more business this evening, the House Judicial and Criminal Committee will recess to the call of the chair. Thank you, everyone. Have a great night.